5 seconds to go. Start. Concerns about road safety are often shaped by individual biases without the opinion being founded on any empirical data. It is easy to overlook the full spectrum of factors that contribute to road safety. In this context, the pivotal legal issue that this constitution bench of 5 judges has to decide is whether, under the existing legal framework of the Motor Vehicle Act 1988, for short MV Act, and the Central Motor Vehicles Rules 1989, for short MV Rules, a person holding a license for a light motor vehicle class can drive a transport vehicle without a specific endorsement provided the gross vehicle weight of the vehicle does not exceed 7,500 kilograms. Besides road safety, the livelihood concern of a large number of drivers of transport vehicles in India also requires an answer from the bench. In this judgment, let us name our driver Shri, who is a transport vehicle driver. As can be appreciated, Shri spends maximum hours behind the driving wheels and is arguably the most experienced one amongst Indian drivers carrying goods and people from destination A to B and so on. Before we set out the relevant provisions, a brief overview of the legal journey that has led us to the above quest would be appropriate. The vexed question was first noticed by a two-judge bench of Justice Kurian Joseph and Justice Arun Mishra in Mukund Devgan versus Oriental Insurance Company Limited, for short Mukund Devgan 2016. It took note of the conflicting views in 8 different judgments of this court and framed the following questions for determination by a three-judge bench. What is the meaning to be given to the definition of light motor vehicle as defined in section 221 of the MV Act? Whether transport vehicles are excluded from it, whether transport vehicle and omnibus, the gross vehicle weight of either of which does not exceed 7,500 kg, would be a light motor vehicle, and also motor car or tractor or a road roller unladen weight of which does not exceed 7,500 kg, and holder of license to drive class of light motor vehicle as provided in section 10(2)(d) would be competent to drive a transport vehicle or omnibus, the gross vehicle weight of which does not exceed 7,500 kg, or a motor car or tractor or road roller, the unladen weight of which does not exceed 7,500 kg. What is the effect of the amendment made by virtue of Act 54 of 1994 with effect from 14th November 1994, while substituting clauses E to H of section 10(2), which contained medium goods vehicle, medium passenger motor vehicle, heavy goods vehicle and heavy passenger motor vehicle by transport vehicle? Whether insertion of the expression transport vehicle under section 10(2)(e) is related to the said substituted classes only, or it also excluded transport vehicle of light motor vehicle class from the purview of sections 10(2)(d) and 241 of the Act. What is the effect of amendment of Form 4 as to operation of the provisions contained in section 10 as amended in the year 1994, and whether procedure to obtain driving license for transport vehicle of class of light motor vehicle has been changed? Speaking through Justice Arun Mishra, the reference was answered by a three-judge bench of Justice Arun Mishra, Justice Amitava Roy, and Justice Sanjay Kishan Kaul in Mukund Devgan versus Oriental Insurance Company Limited, for short Mukund Devgan 2017. The bench concluded that the holder of a license for a light motor vehicle class need not have a separate endorsement to drive a transport vehicle if it falls under the light motor vehicle class that is below 7500 kgs. The reference was answered as under. Light motor vehicle as defined in section 221 of the Act would include a transport vehicle as per the weight prescribed in section 221 read with section 215 and 248. Such transport vehicles are not excluded from the definition of the light motor vehicle by virtue of Amendment Act number 54 of 1994. A transport vehicle and omnibus, the gross vehicle weight of either of which does not exceed 7500 kg, would be a light motor vehicle, and also motor car or tractor or a road roller unladen weight of which does not exceed 7500 kg, and holder of a driving license to drive class of light motor vehicle as provided in section 10(2)(d) is competent to drive a transport vehicle or omnibus, the gross vehicle weight of which does not exceed 7500 kg, or a motor car or tractor or road roller, the unladen weight of which does not exceed 7500 kg. That is to say, no separate endorsement on the license is required to drive a transport vehicle of light motor vehicle class as enumerated above. A license issued under section 10(2)(d) continues to be valid after Amendment Act 54 of 1994 and 28 March 2001 in the form. The effect of the amendment made by virtue of Act number 54 of 1994 with effect from 14th November 1994, while substituting clauses E to H of section 10(2), which contained medium goods vehicle in section 10(2)(e), medium passenger motor vehicle in section 10(2)(f), heavy goods vehicle in section 10(2)(g), and heavy passenger motor vehicle in section 10(2)(h) with expression transport vehicle as substituted in section 10(2)(e) related only to the aforesaid substituted classes only. It does not exclude transport vehicle from the purview of section 10(2)(d) and section 241 of the Act, that is light motor vehicle. The effect of amendment of Form 4 by insertion of transport vehicle is related only to the categories which were substituted in the year 1994, and the procedure to obtain driving license for transport vehicle of class of light motor vehicle continues to be the same as it was and has not been changed, and there is no requirement to obtain separate endorsement to drive transport vehicle. And if a driver is holding license to drive light motor vehicle, he can drive transport vehicle of such class without any endorsement to that effect. However, the above pronouncement did not put the matter to rest. On 3rd May 2018, a two-judge bench comprising Justice Kurian Joseph and Justice Mohan M. Shantanogodar in Messrs. Bajaj Allianz General Insurance Company Limited versus Rambha Devi and others noted that while deciding the vexed question in Mukund Devgan 2017, the three-judge bench had not considered important provisions of the MV Act and MV rules. The bench noted that the following significant provisions were not placed before the court in Mukund Devgan 2017. It is the submission of Shri Jayant Bhushan and Shri Joy Basu, learned senior counsel, that certain distinct provisions pertaining specifically to transport vehicles have unfortunately not been brought to the notice of the court. Section 4(1) of the Motor Vehicles Act 1988, hereinafter referred to as the Act, provides that the minimum age of holding a driving license for a motor vehicle is 18 years. Section 4.2 provides that no person under the age of 20 years shall drive a transport vehicle in a public place. Stop.